Nnamdi KANU case. Chai. Nnamdi KANU is brainy. I told you that Nnamdi KANU is sent from heaven. God knows his whereabouts to Nigeria. He have schooled James Omotosho and so many other of them. And his prosecution counsel, he put them in jeopardy. I will bring an analysis of Nnamdi KANU's case as of the moment. Nnamdi KANU have disseminated them. He have slapped and blowed in their face. Chai! I never knew that Nnamdi KANU is a natural senior advocate. I told you people that when God will do his things, he's going to marvel. He's going to marvel the whole world. I know these things, the video I am about to show you, none of the senior advocate knows this. Nigeria is dying out of the consent of the law, understanding of the law. Good number of them that are answering senior advocate don't even know the law. It's just a title they bought with money. Good number of them bought it with money and with I know you. Like the way it is in the university lecturers, the same way it is in the judiciary. That many of them don't know the law. If what Nnamdi KANU, the video I'm going to show you what he did in the court. Kai! If they know this law, I'm telling you, if the people holding this law, holding this court section knows this law, they would not like to put shame in their face. Now they are on the run. They are on the run. I told you, don't worry, if it doesn't happen today, it will happen tomorrow. They are going to leave KANU out of shame. Or they will shamelessly do something that will arouse. You see, they will shamelessly do something that will arouse. Let me tell you, a time will come. You know, the people that are sitting for Nnamdi KANU is sitting on pressure of the person who told them to hold him. They are holding them captive, like others are saying, I've resigned from his case. That is the way they will be resigning. They are just elongating it so that it will take a little time and they will resign. They will give it to another person. That is why I told you, they are ready to hold Nnamdi KANU forever because they know he is telling the truth. And no one of them wants to go against their puppet master. That is true. So let me not waste your time. Watch what happened, what transpired in the court as I'm talking to you. What is going on? Nnamdi KANU have destroyed the whole court and they are in shame. They said we are going to discuss or look into it the way it is. Come on, Nigeria and the law. Here they watch the video. And before you go, make sure you subscribe to this channel. Share it to people.
Today is Nnamdi KANU's court day, the 5th of November 2025. And of course, as you know, that Nnamdi KANU is defending himself in court. And as the court case is winding down, today happened to be a very blockbuster court day. So gather yourself together as I welcome you to Nnamdi KANU's court day again. This is the entrance of Nnamdi KANU. As you can see, as usual, Nnamdi KANU in his glory, in his greatness. As you are aware, Nnamdi KANU's court cases these days is receiving a very huge blackout. In fact, the media, the press, friends and family, many of which are not even permitted to enter the court. I do not know the kind of offense a man will commit that you don't want us to see what is being said about him and how he's handling his case himself. But notwithstanding, God in his infinite mercy made sure that today's court case, there is a transcript, something huge Nnamdi KANU tabled before the court word for word. I have it here for you. So whatever you're doing, I advise you to leave it and come and watch this video, or go and finish it up, and when you're done, you come and watch this video because you don't want to miss a bit of it. So listen very carefully, because what I'm about to read to you is the transcript of what happened in court in Nnamdi KANU's words to the court. Listen very carefully. I'll read. So this is the adumbration of Mazi Nnamdi KANU in court today, November 5th, 2025, before the Honorable Justice James Omotosho of the Federal High Court. Listen. Number 1 is the opening proceedings. At the resumed hearing on the 5th of November 2025, Mazi Nnamdi KANU appeared in person. He requested a brief 5-minute recess in the judge's chambers, explaining that what he had to disclose to Omotosho might embarrass the judiciary of Nigeria if said open in court. Justice Omotosho declined this request, directing that all submissions be made publicly. Mazi Nnamdi KANU then proceeded to seek the adoption of his motion on notice and the accompanying written address, urging the court to grant the reliefs sought. But Awomolo SAN, which is the prosecution lawyer, objected. He said, "Objection, my lord." And the court sided with Awomolo that KANU should not talk about his filed motion challenging the non-existence of any law challenging the offenses for which he is accused of. That the court will take it at the end of trial today. But then KANU was visibly annoyed, but he maintained a composed, firm demeanor throughout the session. Justice Omotosho was notably attentive and cautioned Nnamdi KANU to keep his gunpowder dry. He should calm down. And also, he said that Nnamdi KANU is free to consult a criminal lawyer at any moment he likes. Justice Omotosho flatly resisted entertaining arguments on the constitutional validity of the charge and jurisdiction at today's hearing. He said, no, this trial is legal. KANU, however, proceeded to address the court on the issues why he would not enter his defense. This is where it gets interesting. So let's go on. This is the core of the oral adumbration. Mazi Nnamdi KANU's address centered on the jurisdictional foundation of the case. His submission was that the entire trial is void ab initio because it rests on a repealed law, namely the Terrorism Prevention Amendment Act 2013, which ceased to have legal existence following the Terrorism Prevention and Prohibition Act 2022, a year before. Nnamdi KANU argued that jurisdiction is the lifeblood of adjudication, not a procedural formality, citing the Supreme Court in Madukulu versus Nkendelim 1962, which held that a court is competent only when the case comes before it under a valid subsisting law. Number 3, his argument 1, that jurisdiction ceases when enabling statute is repealed. KANU cited the Supreme Court decision in Afolabi versus Governor of Oyo State 1985, where the court held that when an enabling law is repealed, any right, privilege, or proceeding founded upon it automatically collapses. It cannot be saved by judicial contrivance or implication. He emphasized that once a statute is repealed, any trial under it is ipso jure null and void, since the law ceases to confer jurisdiction. His argument 2, bordered on Section 32, subsection 12, and Section 13 and Section 1.3 of the Constitution. KANU read out Section 36, subsection 12 of the 1999 Constitution as amended. He said, a person shall not be convicted of a criminal offense unless that offense is defined and the penalty thereof prescribed in a written law. He submitted that a repealed statute is no longer a written law, and therefore any charge predicated on it is constitutionally a nullity. Further, under Section 1, Section 3 of the Constitution, Kanu said, if any other law is inconsistent with the provisions of the Constitution, this Constitution shall prevail, and that other law shall, to the extent of the inconsistency, be void. Thus, even a hypothetical saving clause cannot resuscitate a repealed criminal statute, as it will be void for inconsistency with Section 36, subsection 12. Nnamdi KANU. Very intelligent. Thus, even a hypothetical saving clause cannot resuscitate a repealed criminal statute, as it would be void for inconsistency with Section 36, subsection 12. His argument 3 said that judicial precedence and constitutional supremacy. Kanu referenced Utah versus the state 2016 and Abacha versus the state 2002. Both of which reaffirmed that once the statute creating an offense is repealed, the jurisdiction of the trial court ceases. Nnamdi KANU. Immediately, a court of law cannot breathe life into a statute that has ceased to exist. He argued that by proceeding under a repealed statute, the court could effectively be enforcing a non-existent law contrary to both constitutional and judicial authority. Now, argument 4, disobedience to the Supreme Court's directive. Kanu drew attention to the binding directive of the Supreme Court in his judgment on 15 December 2023 in FRN versus Kanu, where it held that the only potentially triable allegation formally, which is count 15, fell under the Customs and Excise Management Act, SEMA, not the repealed terrorism provisions. He accused the trial court of refusing to realign the charge under SEMA as directed, thereby violating stare decisis and judicial hierarchy. He said, a trial court cannot pick and choose which portions of a Supreme Court judgment to obey. His argument 5 says it's about the Supreme Court's own error on ongoing correction. Nnamdi KANU pointed out that even the Supreme Court itself may have erred by incuriam when it described the repealed TPAA 2013 as extant in its 2023 judgment. By then, the TPAA 2013 had been repealed by TPAA 2022, which is the Terrorism Act. He revealed that he has taken legal steps to bring this error to the Supreme Court's awareness, hence refrain from elaborating further in open court. The argument 6 says cross-border jurisdiction and double criminality. Citing Section 76, subsection 1D3 of the Terrorism Prevention and Prohibition Act 2022, Kanu argued that for any alleged conduct committed outside Nigeria, in this case Kenya, jurisdiction can only arise upon proof that the conduct constitutes an offense under the law of that foreign country, a double criminality requirement. He said the prosecution failed to produce any evidence from Kenya showing such criminalization, rendering the jurisdictional gateway shut. Argument 7, unlawful detention. Kanu invokes Section 35 of the Constitution, which guarantees personal liberty, stressing that detention without a valid subsisting charge amounts to executive detention, not judicial detention. He condemned such practice and asserted that his continued detention violates the African Charter domesticated in Nigeria. Now, on the allegation of bias and perception of partiality, Kanu expressed deep concern that the court's repeated refusal to address jurisdiction and the apex court's directive could create an appearance of bias. He said, "It creates the perception that this court is not neutral, that it is more concerned with sustaining the prosecution's narrative than upholding the law," which is true. I agree with Nnamdi KANU. He added, with evident restraint, that justice must not only be done, but must be seen to be done. Very important. Omotosho then asked Kanu if he, as a judge, has done something to make Kanu suspect him impartiality. To suspect his impartiality, Kanu said, "Not yet." In fact, I think Kanu was very kind and very diplomatic with Omotosho there, because of course, for Kanu to even sack his lawyers, it's obvious that the judge himself made that possible by his biasness. So this is me saying clearly, if Onyendo had decided to be very calm with Omotosho, I personally would say, Omotosho, you are biased. You are biased. Let's go on. 11. Concluding prayer. Mazi Nnamdi KANU concluded that no valid, subsisting or cognizable charge exists before the court, and told Justice Omotosho that even if I don't enter my defense, my lord, you cannot convict me because you can't convict someone without a written law as per the non-derogable Section 36, Section 12 of the Constitution of Nigeria. So, my lord, our efforts here are wasted. He urged Justice Omotosho to 1. Hold that no valid charge exists under Section 36, subsection 12 of the Constitution. Recognize also that any trial on the repealed TPAA 2013 violates constitutional and Supreme Court authority. He should also declare the proceedings a nullity for want of jurisdiction and order his immediate release from custody. He closed by saying, "It would be a deliberate deviation from the Constitution and a conscious embrace of illegality for a court of law to compel someone to enter defense without any charge. That is a weighty responsibility no judicial officer should carry." Very, very important. And we have been saying this here on our channel, that the burden is now on Omotosho. How is he going to charge Mazi Nnamdi KANU? That is a weight too strong to bear. Judicial response. Justice Omotosho listened attentively but declined to entertain further submissions on the constitutional objections of this stage. He cautioned Kanu to keep his powder dry, indicating that the issues raised will be addressed at a more appropriate procedural point at the end. He decreed that Kanu must enter defense on the 7th of November or he will be foreclosed and his rights will be foregone at that moment. Holy, Nnamdi KANU is another savior. That was very extensive from Onyendo himself. In fact, I call it a whitewash. Mazi Nnamdi KANU actually schooled the court today. I doubt if Omotosho in all his education knows many of the things Nnamdi KANU talked about, the quotations, and the strength of the submission. I doubt if anybody in that court can do this. Nnamdi KANU is not a lawyer by profession, but I'm telling you, Nnamdi KANU is a senior advocate.